This is about the concern that when you gift something to your daughter, your son-in-law might take it. As a case study, even though I trust my son-in-law, I'm still worried when gifting to my daughter. You never know what might happen in life, and if they get divorced, won't what I gifted to my daughter end up being taken by my son-in-law? That's the concern. Today, I'll introduce a way to solve this issue. This is also a client case. In fact, it's not a case of a specific individual. When discussing living trusts or similar trusts with seniors, this topic comes up almost 100% of the time without exception. This is the case of Mr. A. He lives in California. He also has a married daughter, and his daughter's marriage is currently very harmonious. However, Mr. A says this: his daughter and her husband are getting along well, but you never know what life will bring. These days, divorce is common, so I want to give a gift to my daughter now, but I'm worried about what will happen if it just ends up with my son-in-law later. I want to help my daughter now. I want to help her and her husband, but I'm concerned about the possibility of a situation where I don't want to see the source of the gift later. So, especially since Mr. A is in California, he is more worried because he knows that California is a community property state. What this means is that a community property state is like California. It means that any assets acquired during the marriage are basically considered joint property of the couple. So while you could technically label it and maintain it as separate property, there's a concern that this might not hold up well in California, which makes it even more worrisome. Let's take a look. Now, before we get started today, this channel provides professional information on U.S. law, tax law, and financial planning. Not just this video, we will continue to upload many more beneficial contents in the future. I hope you don't miss out on them. To ensure that if you haven't already, please make sure to subscribe and like right now. Alright, let's get started. On the surface, this might seem simple, but it's not. The idea is that since I'm giving it to my daughter, and not directly to my son-in-law, even if they divorce, wouldn't it just remain with my daughter? In reality, it's not that simple, especially during marriage, initially. Since I'm gifting it to my daughter, it is considered separate property. However, if it's not properly managed, it can get mixed up, and if they unfortunately end up divorcing, it could potentially become a problem. Let's briefly look into why this could become an issue. Earlier, I briefly mentioned community property and separate property. There are several states. California is included among them. It's called a community property state. In this case, the assets acquired by the couple during marriage are basically considered joint property of the couple. Assets acquired before that are considered separate property. And also, during the marriage, if a specific person receives a gift or inheritance, for example, if the husband inherits from his father or the wife inherits from her mother, it is basically considered separate property. However, the issue is that this designation does not always remain intact, even if the assets are classified as separate property. Over time, if they get mixed with community property, it becomes difficult to claim that it is separate property. So, is this issue exclusive to community property states like California? Not necessarily. Even in separate property states, assets can be mixed in this way, leading to commingling. If this situation continues, it can become difficult to clearly prove ownership of the asset. Therefore, these issues are not exclusive to California, but community property states do present a higher risk of complications. It can be addressed on a larger scale. In the event of a lawsuit, there is a high possibility that it will be considered marital property. So, in such cases, the question is, what is the method to ensure that when I give something to my daughter, it doesn't end up with my son-in-law if things go wrong later? There are several alternatives. I will tell you about 5 of them. Lastly, except for the 5th one, I don't really recommend the 1st to the 4th. However, I will mention them first. Practically, those options have limitations. Let me explain. First, there is something called conditional gifting. It would be a limited gift. The concept is that parents set specific conditions when gifting assets. For example, if I give this to my daughter, it remains her asset only if it is maintained as separate property. Otherwise, it is returned to me. So, it's about setting such conditions. That's why it's called a conditional gift. Nevertheless, there's a limitation to this. If the condition is violated, not only is a complex legal process required to reclaim the asset, but proving or managing whether the condition was violated is practically difficult before a divorce occurs. Therefore, it's not highly recommended. The second method is using a legal entity like an LLC for gifting. For example, the parents establish an LLC, transfer the asset they want to gift into the name of the LLC, and then gift the LLC shares to their daughter. Again, it's not bad, and while there are advantages or benefits, the limitations are clear, even if the daughter holds the LLC shares during her marriage. Let's say the value of the LLC shares increases using community or joint marital funds. Then, this increase might be considered community property. Also, managing an LLC or such corporate management is complex, and if used improperly, there's a limitation where the asset protection effect weakens. Then, the third method is, this might seem like a method, but it's simply about maintaining the separate property status well. For gifted assets, Keep them in a separate account under your name, or in the case of real estate, by not recording what I received under joint ownership. In other words, by registering it as separate property, you maintain its character as separate property. The limitation is that it's not easy as time goes by and the couple engages in economic activities together, proving that these assets haven't mixed. Is not simple, which is why it's not highly recommended. It requires thorough management, record keeping, and storage, but in reality it's difficult. The fourth point is still uncommon in our culture. It's called a prenuptial agreement. It's referred to as a prenup agreement or a postnuptial. Before getting married, a couple can draft a prenuptial agreement or a postnuptial agreement after marriage. This refers to a situation where they agree to designate certain assets as separate property. The limitation is you need to get agreement on this. If one refuses, it's difficult to enforce. Also, the fairness of such agreements can become a subject of legal disputes in divorce proceedings. Moreover, the agreement itself might not align with emotional expectations. It can cause discomfort and conflict in the marital relationship. Therefore, it can be considered an uncommon option. So finally, the fifth option, what is it? Is the solution through an irrevocable trust. These issues mentioned above, it can be said to be the most powerful method to solve them structurally as much as possible. The concept is an irrevocable trust. Then you transfer the asset into a trust. The legal ownership of the assets is completely transferred to the trust, not me. And then, here, the dad establishes this irrevocable trust and transfers the assets he wants to gift into the trust. Who is the beneficiary of this trust? It's the daughter who is the trustee. You designate some other independent third-party trustee. Then the trustee manages these assets well and distributes them to the daughter when needed. So what are the advantages? There are several things. First of all, it's asset protection. Trust assets. This is what's called an irrevocable trust. And because it will strictly maintain independence, it must be maintained. Therefore, since this is legally owned by the trust, the daughter, in case of divorce or any creditor issues, it is said to be protected from any claims by creditors or spouses. And the second is mixing. The mixing of separate property and community property mentioned earlier. This is also prevented because the daughter does not have direct authority over this trust. It is not directly owned, which means it does not mix with community assets. And that's an advantage. The third is a specific provision of this trust, which is called a spendthrift provision. The terminology isn't what's important. However, in this document regarding the trust asset, can specify that neither the spouse nor creditors can access the trust assets. Therefore, it can maximize such effects. And fourthly, you can also secure flexibility in distribution. What does that mean? This is the trustee. The trustee can decide on the timing, method, and scale of distributing the asset. The daughter might also think this way: I trust my daughter, but I might want to prevent her from spending it recklessly and spoiling her. This way, it also has the advantage of preventing the misuse of assets. Of course, there are also disadvantages or considerations to keep in mind. What this means for parents is that since it's an irrevocable trust, once the trust is established and the assets are transferred, parents can no longer retrieve or alter those assets. And secondly, there are also operational and management costs. There are costs involved in establishing a trust. And while a third party might manage it for free, there could still be fees involved. And thirdly, since transferring your assets into an irrevocable trust is essentially a gift, there are tax issues or gift tax filing requirements that must not be overlooked. Nevertheless, if you want to gift to your daughter, as mentioned earlier, and hope that she and her husband use it well, but in case they separate, you want to prevent your son-in-law from making any claims, then considering an irrevocable trust is the most effective solution for that purpose. Ultimately, this irrevocable trust, using a revocable trust, is the most desirable and certain way to protect the daughter's assets safely and address the client's concerns. I hope today's content was helpful as well. I believe there are many people around you who need this kind of information. This channel is a space for growing together with you. I remind you once again to subscribe and like. I hope you don't miss out on essential information next time as well. Also, please help by spreading this information to those around you. Thank you.